SJC-11755, Commonwealth v. Victor Figueroa.
Good morning, Chief Justice and Associate Justices. I'm Michael Hicks, and I am representing the defendant appellant, Victor Figueroa, in this case. The defendant was convicted of 2 crimes, mayhem and assault and battery by means of dangerous weapon causing serious personal injury. However, he can only be convicted of one of those crimes and sentenced to state prison on one of those crimes. The more serious crime would be mayhem. The other conviction has to be vacated, and he cannot be sentenced on that charge as a matter of constitutional law, the double jeopardy under state and federal law.
What if the stabbing had been...
Oh, I'm sorry.
Right.
Go ahead.
What if there was a stabbing and there are 2 stab wounds, one to the knee, let's say, to sort of incapacitate the person,
Yep.
and then the other to the face?
Yes, I think that could be separate acts, and that really is the issue in this case, is whether the stabbings and cuttings in this case was one act, and I think that scenario would present a separate act, assuming it was charged properly.
Question of physical closeness, the closeness in time,
Well, it's a question of you have to use various factors. Closeness of time is certainly one. I would say proximity of the injuries and the nature of the injuries in terms of cutting or shooting would be different. When you put them all together, you have to draw a conclusion, and you have to draw upon various facts to come up with that conclusion.
So here, the victim's face was slashed, and there was a big slash across the neck.
Yes, well,
And so those were 2 different slashes, right? I mean, was there anything in the evidence that suggested this is all just one continuous slashing? I mean, were the slashings all connected?
There was
Physically connected. I mean, was it all just like one big slash, or was it?
No. There was, and I included this in the appendix of the picture of the victim's face. There was 3 cuts that are very discernible from her, and I would say that was one act. And in terms of the testimony, the witnesses who were eyewitnesses, and this was done in broad daylight, testified that the defendant was in effect punching her. They didn't see the knife, but there was repeated cuts, and that's how the cuts to the face occurred. That's the only reasonable.
So 3 different times.
Yes, but that can...
3 different times within one. I understand that, but you just answered Justice Cordy about the knee. Suppose it was another stabbing, another slashing, and it was the chest, or it was an arm, or it was a shoulder. How far down the body do you have to go before it becomes a separate act?
That I don't know.
But I mean, how do we give the judges some guidance here?
Because in this case, you have a very specific charge of mayhem, which requires a specific intent to maim. Specifically, in this case, is certainly a disfigurement case. It happened in close temporal proximity. You can't really separate temporally those actions. You can't say which one came first, which one came second, which one came third.
And do you need to do that?
Well, in terms of defining whether they're one act, that would certainly be an important consideration. And all the wounds to the face, and I would say that that's actually, it's not cutting her throat to kill this woman in this case, or to do some other sort of injury. It's all intended to cut and disfigure, and he's made that clear in his own written statement.
Could this have been charged as 2 counts of mayhem or 3 counts of mayhem?
Not under the facts of this case, no, not to the face.
What about a separate act of mayhem for the throat?
No, these all occurred with the same specific intent to disfigure, all at the same time, with the same weapon. In terms of the constellation of facts, I think they're very tightly wound in this case, and very specific in this case. Now, interestingly, there was a separate wound to the woman's arm in this case that apparently was not prosecuted, and there was a slash mark to her arm, and that could have been a different assault and battery by means of a dangerous weapon. But the wounds are very specific in terms of disfigure, and he's clear about that in his written statement.
So he was convicted of assault and battery by means of a dangerous weapon, but it was on an instruction that had to do only with the acts having to do with the cut on the throat.
Yes, and I would more characterize it a cut on the jawline of the face. It doesn't really go down that far. I don't know if that's any comfort to the victim in this case, but it's definitely, I would say, you would have to say that where the lower cut, it would have to be considered part of the face as well, because it is part of your presentation to the outside world. People would notice it just as much as they would to your face, just as much as they would to the forehead. So I don't think that distinction is important in this case.
So is the problem here that the judge didn't give the right instructions?
Well, I think the problem here is the judge, looking at the evidence of this case, really, really wanted to punish the defendant after he was convicted, particularly. 20 years is the maximum penalty for mayhem. Whether there should be more or there should be a subsequent offense.
Well, but the judge's motivation isn't really what I was asking you. I was asking you, is there a problem with their instructions?
Well, the instruction, I would say that you cannot pick and choose body parts. Now, I know that certainly happens in some cases.
Well, suppose it was the arm, and she was saying that the assault and battery with the dangerous weapon was related to the arm.
I would say yes, but I would say counsel would also have to weigh in on that, because I do think there would be insufficient of mayhem on the arm on this case, and I think in most cases. But I think a distinction can be made by instructions, but not in this case.
I know that this case was prosecuted as a mayhem case.
Yes.
But if instead of bringing, if no mayhem indictment had been obtained or even sought, and instead there had been one separate count of assault and battery by means of a dangerous weapon for each stab, that there would be no duplication there. Would there duplicativeness?
There would be under the facts of this case.
Why?
Because there was one single brief attack, and I believe that I cited Diaz in another case.
But there was an intent. I mean, that's why I'm saying, what if this had not been mayhem?
Yes.
But instead had been a series of assault and batteries by means of a dangerous weapon, for which only a general intent was required.
Given the nature of this attack, the answer would be no. I think it's considered one act, even though you can break it down and say there are 3 acts or more. Now, I think you would illustrate that point by looking at a case like Maldonado, where a cut was administered, or in that case, a shooting. Then the person came back and did it again. There was a break, but I mean, this was one assault that maybe lasted a minute. I mean, I'm sure it felt more than that, but I mean, this was. He grabbed this woman, according to the testimony of the eyewitnesses. Looked like he was punching her. Cut. She tries to run away to a place of safety. He runs away, and he's later caught. And I think that is simply one act. You can't go wound by wound by wound, because there's a cut to the woman's lip. There's a cut to her ear as well. Presumably when he grabbed her in the first, there would have been an assault and battery there. So you can't keep on.
So you can't do it by wounds, but you said before if it was the knee.
Yes, but I think you could draw. You have to, at some point, you have to draw.
Because the knife, let's just say, was used for the knee, as opposed to having it be, whacking her in the knee. Let's just say it was, another knife, the same knife used, and it all took less than a minute.
If there was affirmative evidence that this was a gratuitous injury, an insult injury, so to speak, or it was accompanied by other verbal conducts or something like that.
In other words, if he said, "I want to make you feel pain,"
yeah,
and inflicted 5 stab wounds, you might get 5 separate indictments, for each one for different level of pain.
Yes, there are scenarios. I mean, if it was rationally taken, I'm going to cut you now. No, I'm going to cut you now. It's a gruesome case, but I mean, that would be a rational basis, but this was clearly one simple motivated attack in a very brief part of time, and that's not to apologize for the defendant. I mean, his specific intent clearly was to mutilate this woman, disfigure her, and he did so, but he can't be convicted because he's for other crimes that are subsumed within that mayhem by the specific statutory language of both crimes.
Who also said he couldn't be charged with separate crimes?
Well, separate crimes in terms of he could be charged for
Separate acts of assault and battery.
yeah, if you can separate them out.
But you're saying you can't. Just
Well, not under the facts of this case. This case would be one act, even if it's broken down into 3 separate cuts. It is one act as a matter of law in this
You
case.
say one act, but 2 separate slashes. I'm looking at Exhibit 2. It
Yes.
shows it clearly, 1 slash along the face.
Yes,
And then another slash from the ear down across the throat.
yes,
So that's one act, even though it's 2 quite distinct, at least the jury could have found.
yes.
2 quite distinguished.
No,
distinguishable slashes.
it is one act under the circumstances of this case.
suppose it was a gun instead of a knife and there was 2 shots.
If those shots happened, pull the trigger, boom, boom, I'd say it'd be one act. That's my understanding of the word act. A legal act can have acts within it. That's my understanding of the law in this case, and I think that's what happened in this case. So I would say that the case, he can only be convicted of 1, Your Honors, and I believe that would be mayhem, and he would be sentenced to the maximum on that crime.
All right, thank you.
Thank you, counsel.
Thank you, Your Honors.
Good morning. May it please the court. My name is Jessica Langsam. I'm an assistant district attorney for Middlesex, appearing on behalf of the Commonwealth. The mayhem and the assault and battery by means of a dangerous weapon causing serious bodily injury to this victim were not duplicative. They are cognate offenses, as the appeals court recognized, and as this court has recognized, but where the jury was instructed that the mayhem, they were only to consider the injury to the victim's face with respect to the mayhem and the injury to the victim's neck with respect to the ABDW-SBI. These were each significant injuries.
Do you think you can always charge by where the injury is? I mean, does the fact of, is there any temporal element to this at all?
Your Honor, my review of the case law has not found any temporal element. I know that in Commonwealth versus Maldonado, which involved a shooting where someone was getting retribution for making advances on a girlfriend of a sister of a Latin king or something like that, the court did note in that opinion that the defendant shot the 3 victims, then paused, and went back and shot them again. But in other cases, Your Honor, as I've cited in my brief, Commonwealth versus Simpson, Commonwealth versus Page, these were incidents where the defendant, in an ongoing stream of attacks against the victim, either in Simpson, for example, the defendant hit the victim in the head with a hammer, stabbed the victim in the neck with a knife, then slashed the victim's neck with a knife. And where the jury was instructed that each crime had to be based on a separate act, these are not duplicative. And it's here, even though they're cognate offenses, or as Your Honor, Justice Spina has just asked, if these had been charged as separate ABDW-SBI, as long as each is based on a separate act where the jury was instructed here, then there's no violation, there's no problem with violation of double jeopardy principles. The defendant hasn't received multiple punishments for the same offense. And in fact, if the defendant had just stopped after one of the slashes, then the victim, of course, wouldn't have had to endure the pain, the surgery, all of the trauma that goes along with having been brutalized in this way. Justice Kottmeyer, in her order, in the sentencing memo that she issued, which is attached to my brother's brief in the record appendix at page 35, noted that these were separate and distinct acts that caused separate and serious permanent injuries to the victim. Justice Kottmeyer also...
You also say that they were not necessary to
Yes,
each
Your
other?
Honor. Justice Kottmeyer also said that they were not necessary to each other. And that's what takes this case away from a case like Commonwealth versus Figueroa, which this court decided in 2013. Figueroa was the case where the defendant was convicted of indecent assault and battery on a child under 14 and statutory rape. Where the victim was under 14, that was a cognate or a lesser included offense of the rape. The court concluded that even though it had been presented to the jury for these separate crimes, and the jury had returned separate convictions on this, that the judge could determine whether or not it was part of the same act, and that it was part of the same act there because in order to commit the rape, the indecent assault and battery was moving the victim's shorts and underwear to the side. Here, the slashes were independent and were not necessary to each other. So
the mayhem, in effect, was completed after the first slash to the face.
Yes, Your Honor. Yes, that was the complete crime. And
If there had been another slash to the face, would that be a separate mayhem?
it could be, Your Honor. Each of these crimes, for example, the mayhem was a 7-centimeter laceration across the victim's left ear and cheek. The ABDW-SBI was a 10-centimeter laceration from the victim's left earlobe to the center of her throat. The injuries were so serious that a paramedic had to join the Woburn Fire and Rescue truck on the way to the hospital. It had gone through all the
Well, I
levels.
understand they're really serious,
Yes.
but that's not our issue, right? I mean, I
Yes,
don't
Your
mean to
Honor.
sound callous, but that's not what we're trying to figure out.
Then, Your Honor, if there had been another serious injury inflicted on the victim's face, that could have been charged as another count of mayhem. There were other injuries, as my brother has pointed out, as the court has indicated. There was an injury to the victim's arm. That was not charged as a separate assault and battery with a dangerous weapon.
Your view is it could have been.
It could have been, and the Commonwealth chose not to do that. Justice Kottmeyer recognized that this was an issue during the defense case and asked for input from both Commonwealth and the defense on this issue. Then there was a hearing. The defense objected to the narrowing in this way. Justice Kottmeyer instructed. The defense counsel also filed a motion, which is contained in my brother's record appendix after sentencing. And the judge then wrote in the sentencing memo the reasons for the separate instruction and basically narrowing the Commonwealth's evidence. So there were these additional cuts. They weren't charged. The Commonwealth then, as the evidence comes out, proceeds with the mayhem with respect to this cut and the ABDW-SBI with respect to this cut.
Do you think this becomes a judge question? In other words, the jury finds there are separate and distinct acts, and then the judge decides whether that it's all one event? I mean,
well, in Sewero, Your Honor, this court said that it was to the judge to make that determination, and where that case involves an indecent A and B and a rape, it looks like it's specifically relating to an indecent A and B or relating to sexual assault.
do you think Sewero would apply here?
Well, Justice Kottmeyer actually did sort of apply Sewero here and concluded that these were separate crimes. And this
Separate acts, you mean?
I beg your pardon, Your
Separate
Honor?
acts.
That they were separate acts and that the separate crimes were based on these separate acts.
Right, but doesn't Sforro essentially merely say that the judge is to perform the role which every judge performs in a criminal case, that is to see whether there's sufficient evidence to support a finding of a separate act as opposed to making an independent finding on his or her own?
Yes, Your Honor, but I think that Sewero, in Sewero, where it was presented to the jury had already returned separate convictions for each of these separate acts, and then this court said, well, they really were part of the same act, and in these types of cases, we're going to have the judge make this determination as to whether it's part of the same act.
Right, but isn't that essentially meaning that the judge found that no reasonable jury could have found them to be separate acts since they were part and parcel of the same act?
No, I don't think so.
Well, I mean, yes and no. A reasonable jury did find that they were separate acts, and then the court concluded that they were actually part of, they actually are separate acts, and I think this is part of maybe a language issue that has come up in a couple of the cases presented to the court this morning. This was a single criminal event with discrete and separate acts that caused discrete and separate, obviously, injury to the victim.
You know, one of the problems that flows from this kind of an analysis is, supposing there were, in fact, 5 or 7 mayhem counts, you could actually end up serving a more time on 5 mayhem counts than you could on a second-degree murder conviction.
Yes, Your Honor. You're right, with a 20-year in prison penalty for mayhem, yes, served concurrently. This was also, as Justice Kottmeyer noted in the sentencing memorandum, this defendant, this defendant had been released from prison, I'm not sure not a long period of time before he committed these acts. He had been in prison for attacking a former girlfriend who had obtained a restraining order against him. He entered her home. and attacked her with a machete. And when she put her hands up to protect her face, she lost one of her fingers. And he was convicted of mayhem in that case, too, and I believe he served 17 years in that case. And so that's the posture, or that's the background where Justice Kottmeyer was imposing sentence in this case. So it was a sentence of 19 to 20 years for the mayhem and a consecutive sentence of 14 to 15 years for the ABDW-SBI.
So the sentencing principle which you're asking us to establish is that when there is a separate and distinct act, you can be punished for it.
Of course, Your Honor, yes. And there's nothing new. This flows naturally from the case law. I've cited Justice Brown's concurrence in Commonwealth versus Paliki, which explains that the test is the Morey test, which is based on Blockberger, where the legislature has determined that each crime has an element that the other does not, then there can be convictions for multiple crimes based on a single act, whereas in this case we have cognate offenses, or even if we had separate crimes based on the same act, then you have to look at the stream of events and are they really the same act or are they separate acts? Here, where the jury was properly instructed, according to all the case law in the Commonwealth, these convictions were proper. And for all of those reasons, I'd ask that this court affirm both convictions for mayhem, and for the ABDW-SBI. If there are no further questions, thank you, Your Honor.